The only people who don't want to disclose the truth are people with something to hide.
Born and raised behind enemy lines, forged in the fires of a liberal stronghold, and tempered with the wisdom of the ages. Fasten your seatbelt and get ready for full contact with Eric Rush.
Welcome back to Full Contact with Eric Rush Live. This is Eric Rush. Thank you for joining me here on this Labor Day. No vacation for me. Of course, I told you I took a vacation in early August, so I wasn't due. And I thank you all for joining me. This hour we have a very interesting topic that I want to get into right away because it can go fast. And as a matter of fact, I think I'm going to wish I had booked this guest for a little longer, if not a lot longer. But Attorney Montgomery Blair Sibly is my guest today. He's one of the oldest, and he's a member of one of the oldest and most distinguished families in the Washington, D.C. area. He is, from what I read about him, the hero to some, the bane to others. The left-wing press, they say some interesting things about him, sort of similar to the things that they say about me. We're terribly rotten people, I imagine. At any rate, Montgomery Sibley brought litigation challenging the eligibility of Barack Obama to be on the November 6th, 2012 general election ballot. He's represented Deborah Jean Palfrey, the so-called D.C. Madam, and Larry Sinclair, who alleged that he participated in sex and drug abuse with Barack Obama when he was an Illinois state senator. Most recently, Sibley's been involved in a very interesting case. In April 2009, the Obama administration dismissed an indictment against Elizabeth Ann Duke, a self-proclaimed revolutionary and co-founder of a New York City-based communist organization dedicated to Malcolm X and Ho Chi Minh that advocated the violent overthrow of the United States government. Duke, along with 6 co-conspirators, was charged with multiple violent acts against America, including the bombing of the United States Capitol and several additional Washington, D.C. sites. Prior to court proceedings in 1985, she made bail, skipped, and has been on the lam ever since. Without further ado, Montgomery Sibley. Montgomery, can you hear me?
I hear you loud and clear, Eric. Thank you for having me on the show. I appreciate this opportunity to tell the people what's going on.
Well, I thank you very much for your time. And you have I did tell the audience, but I found it very interesting. I know we've never met, but we spoke briefly, and you pointed me to some informations. You know, I wanted to be fair when I put up your your bio, but you have a very interesting pedigree, and obviously you are. I don't know, and I guess it's a personal opinion, but you seem to be a very old-school type of attorney, and that's interesting. I'm going to have to look a little bit more into you, but I suppose the fact that the Huffington Post doesn't like you should probably be enough for me, but, you know.
That's all the qualification I need, I hear that.
Yeah.
And Just so it's clear, I'm not actively practicing law anymore. I got into it with the Florida Supreme Court in 2008 when it became apparent that none of them had taken the oath of office, and they suspended me in retaliation. We went around, and so I don't actively practice anymore. I style myself now as a private attorney general, taking on cases and appearing in person so I can then prosecute them the way I want, rather than what the attorney might dictate to me.
Yes, well, judging from some of the things I read, it definitely looks as though you've been, I don't want to say the victim because you don't seem the victim type, but the target of retaliatory acts within the court system or the culture over there. But I really would like to hear what you have to say about this story, and since the time does go fast, the only thing I'm really going to do is, if you, I've got a few questions, but I want you to get your story out, so I'm only really going to stop for breaks, and we don't have a lot of them. The Elizabeth Duke story, how did you first what first piqued your curiosity about that? How did you first get involved in the Elizabeth Duke story?
That's a great question, Eric. It all began really when I got a little bit of national prominence for suing Barack Obama here in Washington, D.C. on 5 different occasions, challenging his eligibility in 2012 to even be on the ballot, let alone president. And as a result, I was connected, made contacts with, and people started sending me information about other interesting events that occurred regarding Mr. Obama. And when this one crossed my desk, what I got was a link to a docket sheet. Now, in the federal court system, all the dockets are online, and a docket is a list of all the activities that occur in a particular case. In a criminal case, the first activity is usually the indictment, then the arrest, arraignment, and then the setting of bail, after which the case proceeds to ultimately trial or plea agreement, or sometimes, very rarely, the government dismisses a case after a grand jury's already voted an indictment.
Right.
To continue on, I guess. Go ahead.
Yeah. Well, I mean, I from my understanding, and I have had a couple of criminal justice classes, which only gives me enough information to be dangerous, but it would be very, correct me if I'm wrong, it would be very rare, I think, for after a grand jury to have handed down an indictment for that to be, as you said, summarily dismissed, for the government to dismiss the charges. It would have to be a significant reason.
Exactly. And the usual reason is the person is mentally incompetent, has been committed to a long-term facility for the mentally insane, if you will. No sense spending government money, securing conviction against somebody who doesn't even know what planet they're on. Many times the person dies, or they've been convicted in another case and has a long prison sentence, so why add more time on to somebody who's never going to see the outside of the prison cell anyway.
Gotcha.
So there's lots of legitimate reasons for dismissing an indictment. But the curious thing is, when I saw the transcript or the docket sheet for this case against Elizabeth Duke, which goes back to 1988, it was very odd as you first looked at it. I mean, you sort of have to look like a surgeon looks at an X-ray to understand what's going on. But there was no written motion by the government to dismiss the indictment, and that's when the government, the U.S. Attorney's Office, puts in writing why the indictment should be dismissed. It just said an oral motion. So that piqued my curiosity, and I had sort of a terrier complex. I wanted to know why. So what happened was I called the court clerk for the particular judge, whose name is Magistrate Judge Robinson. And if I may, Eric, I'll come back to that magistrate designation in a little bit, but it's very significant.
Right.
When I called the court clerk, I said, hey, you had this hearing in 2009. This indictment was dismissed, and I'd like to get a transcript of the hearing. And she was very nice. She said, you know what, we don't have a court reporter typing down what goes on in our courtroom because we're a magistrate's court. We're not an official district court.
Right.
And as such, we make tape recordings of what goes on. Let me dig into the archive and find the tape recording. So I was sweet-talking her. She was liking it. And she said, hey, I found it. Let me play it for you over the telephone. so she played me the hearing, and I could hear what was going on, and it was very, very strange because it only lasted 21 seconds. Basically, the U.S. Attorney walked up and said, "My name is M. Jeffrey Beatrice, and I represent the U.S. Attorney's Office, and we'd like to dismiss the indictment against Elizabeth Ann Duke." The magistrate, Judge Robinson, said, "Okay," and then the Assistant United States Attorney Beatrice then turned around and said, "I'll submit an order for you to sign later." End of hearing. Now, I practiced criminal law for 5 years. I was a prosecutor as well, and I've never seen that in 30 years of practicing law. It just seemed like something was going on. It was at a hearing date that wasn't publicly announced. There was nobody in the courtroom at the time, so that was pretty strange to me.
Right.
So I asked the court, the court reporter. The clerk for the court. Can I have a copy of the tape? She said, "No, we're not allowed to give those out, but we can get you a written transcript so you can read what was said." And in that process, says they send the tape recording to a court reporter who listens to it, types it up, makes an official copy, and certifies it as official. And then if they send it to you for $5 or $10, depending on the length. So that was fine. I ordered it. And then that took me 3.5 to 4 weeks before I finally, after a lot of screaming and yelling, got the transcript of the hearing. And it was basically what I heard. This attorney named M. Jeffrey Beatrice walked in, dismissed it without explanation, and then the judge granted that and signed an order later in the day, which was filed in the court proceeding. That was very bizarre as a legal practice in my experience.
Yes. Now, what has occurred since then? I mean, I know it's bizarre, and I have read and followed this a little bit. As a layperson, it seems to get a little bit more bizarre to me. Of course, there was not a request made. There was not a request made. They just walked in and said, "We want to dismiss it," and the judge said, "Okay." Now that in itself is unconventional, not kosher.
Very unusual.
Very unusual. I mean, if something's illegal, by all means, tell me, because I don't necessarily know. But I mean, that's very unconventional.
Let me add to the unconventionality, if I could, for a moment more, Eric.
Sure. Yeah, we have a break coming up in about 30 seconds, but we can pick up on it. But just get started and sort of prime us for.
So this will take a second, and we can pick it up after the break. But what the judge, Magistrate Robinson, signed back in June of 2009, which she said, upon consideration of the government's oral motion to dismiss and the record herein, and for the reasons set forth in the government's motion, and for good cause shown, this 17th day of June 2009, the indictment against Elizabeth Ann Duke was dismissed. But of course, there was no reason shown, and there was no good cause shown, and so now a judge has signed an order, and this representing what happened in open court, as we have the transcript of it, which shows she's lying.
Okay.
When a judge is writing an order, Eric, you want to wonder about it. Go ahead.
Okay. That is bizarre. We are here at Full Contact with Eric Rush Live, interviewing Montgomery Sibly. We'll be back.
You are listening to Full Contact with Eric Rush. Stay right where you are, or else.
The only people who don't want to disclose the truth are people with something to hide.